of this hearing is impacts of private companies on human rights in Guyana, and this was a hearing requested by civil society organizations. So here's how we're going to spend the hour and a half together. We will have civil society will speak for 20 minutes. The representatives of the state will speak for 20 minutes. The commissioners will have, and the commission, 20 minutes or less to ask questions or make comments, and then we return to CSOs for 12 minutes and the state for 12 minutes. I would like to acknowledge the presence of Minister Barrett, who is here with his team, and thank you, representatives of the state, for being with us virtually. We also have representatives of the state here physically with us, and I also welcome the representatives of civil society. Before we begin, if you can allow me to do a little advertising, this year, 2024, represents the 65th anniversary of the Commission. It's a commission that has been very devoted and committed to the defense and promotion of human rights in the Americas and the Caribbean. And we have what we think is an enviable record of achievement. Over the last 65 years, acting with the input of thousands of individuals, groups and peoples of the region, we have undertaken more than 100 on-site visits. And with every visit, we had to do a report. We have issued over 1,000 precautionary measures, more than 750 merit reports, 220 friendly settlements, and we have sent 377 cases to the Inter-American Court on Human Rights. So I think you all will agree that's an enviable record of work. All of this with victims at the center of our work and as our priority. Securing the rights of peoples of the region is our priority, but also, of course, in a complementary way, working with the states to ensure that they can comply with their obligations to which they have voluntarily agreed to ratification of treaties is also a big priority of the Commission. So I'm sure you all celebrate with me the 65 years of work of the Commission. I also just want to say something about inclusivity and how we're going to function in this hearing. To ensure that the hearing is inclusive, we ask that all participants, before you speak, to say your name, to say your position, and the organization or institution that you represent. Subsequently, whenever you take the floor, please repeat your name. And we ask that so that those who are visually impaired can identify who is speaking. Likewise, we remind you that those who are online, you have Zoom subtitles which you can turn on, and you can also manage the size of the font or the display size as you need. For those who are not following us on Zoom but want to follow us, I remind you that we do have live stream on Facebook as well as on YouTube, so please do that. So with that, I want to turn to civil society to make your representation. I want you please to pay attention to the clock. I would not want to interrupt anyone and give them time. So please, you can self-regulate by looking at the clock online. Over to you. Civil society? We're not hearing, whoever's talking, we're not hearing anything. Are you all hearing?
Yes. Danuta Radzik, Guyana Oil and Gas Change.org. Can I start?
Please do.
Yeah, so good afternoon all. Many thanks to IACHR for granting us the opportunity to present this afternoon. Right to a healthy environment, rule of law, and justice in oil and gas industry. The oil and gas industry in Guyana, with large commercial volumes, moved rapidly from exploration to drilling to production in a country with limited knowledge, expertise, inadequate policies, or specialized institutions for monitoring and regulating this industry, and with a production sharing agreement highly favoring ExxonMobil over Guyana's interests. The Environmental Protection Agency, EPA, as a regulatory agency, has a duty to ensure and guarantee the substantive and procedural environmental rights enshrined in Guyana's Constitution Environmental Protection Act.
I'm
and
sorry
bind
to
the
interrupt you,
human
Ms.
rights
Radzik,
treaties.
but we're having some trouble here. Let me just figure out what it is. Give me a second. Okay, so Ms. Radzik, the interpreter is saying you're speaking too softly and too speedily.
Too softly.
Yeah, so if you can increase your volume and also decrease your speed.
Well, I'm not sure how to do that.
Just talk louder and talk slower.
Oh my gosh.
Just talk louder and talk slower.
I'm talking very loud. All right, so shall I start from the beginning?
I think so.
Right to a healthy environment, rule of law, and justice in the oil and gas industry. The oil and gas industry in Guyana, with large commercial volumes, moved rapidly from exploration to drilling to production in a country with limited knowledge, expertise, inadequate policies, or specialized institutions for monitoring and regulating this industry, and with a production sharing agreement highly favoring ExxonMobil over Guyana's interest. The Environmental Protection Agency, EPA, as a regulatory agency, has the duty to ensure and guarantee the substantive and procedural environmental rights enshrined in Guyana's Constitution, Environmental Protection Act, and binding human rights treaties, including the right to a healthy environment, public participation, access to information, and access to justice in environmental matters. EPA's failure in its duties and obligations re the oil and gas industry. The failure to employ highly specialized and experienced petroleum, geological, and environmental engineers for the EPA has resulted in a lack of expertise and capacity to protect the environment and health and well-being of Guyanese people. The EPA has waived exempted EIAs for at least 10 onshore projects, including a gas-fired power plant, Schlumberger's radioactive source storage and calibration facility, Goya's waste treatment facility, Tiger Rentals waste facility, Schlumberger and Halliburton's liquid drilling mud plants, etc. Of the 19 EIAs, environmental impact assessments, on the EPA website, there is not one for onshore oil and gas projects. Section 11 of the Environmental Protection Act outlines projects requiring EIAs. These include the extraction of natural resources or any project which may significantly affect the environment. The hazardous nature of oil and gas onshore projects warrants EIAs. Ghana has two appeals bodies, the Environment Assessment Board, the EAB, and the Environmental Appeals Tribunal, never established. The functioning EAB's lack of independent experts and environmental professionals instead of appointed high-level government public service, some linked to the oil and gas industry, calls into question its independence and expertise. If the EAB upholds EPA rulings, there is no other recourse except through the courts, an expensive, difficult, lengthy process and an impediment to access to justice. Even though Guyana is currently producing approximately 650,000 barrels of oil per day, estimated annual project waste for 2 oil projects for 3 years was 15,310 metric tons, or close to 34 million pounds, 85% of which is to be transported onshore. However, there is no EPA information on hazardous waste, chemicals used, treatment standards, or shipment of waste as required by EPA's recording and reporting form for all companies generating hazardous waste. As the oil and gas industry expands tenfold, amounts of hazardous waste will increase, with additional risks to health, safety, and well-being of Guyanese communities. Increasing river and ocean traffic increases risks of hazardous waste spills into the Demerara River and Guyana's marine environment. which would be an unprecedented environmental disaster. We see the devastation from Tobago's oil spill happening right now. Access to justice in environmental matters. In October 2023, the Attorney General and Minister of Justice asked the courts to impose higher costs to prevent citizens from filing, in inverted commas, frivolous public action cases related to the oil sector. Notice for judges to comply with this is particularly egregious. Specific environmental risks. Schlumberger, who operated a radioactive source storage and calibration facility with an injunction and cease order still in place, also operates a liquid mud plant and dry bulk facility situated near to residential properties and communities without an EIA or known environmental permit. According to Schlumberger's chemical safety sheets, risks of water-based drilling fluids include acute oral toxicity, acute inhalation toxicity, category 4, skin corrosion, serious eye damage, produces hazardous combustion products, and causes cancer and reproductive toxicity, according to the U.S. State of California Safe Water and Toxic Environmental Enforcement Act. The same chemical safety sheets identify 42 toxic and polluting chemical substances used in Schlumberger's drilling fluids mud plant. 13 of these are classified by OSHA, NTP, and IARC Group 1 as known human carcinogens. 25 are classified as immediately dangerous to human life and have an advisory not to be allowed to enter drains, watercourses, soil, and not to be released to the environment. 21 are highly combustible with unusual fire and explosion hazards, including that dust or fumes may form explosive mixtures in air. Schlumberger has no fire prevention, radiation exposure, chemical spill, hazardous discharges into air, water, or soil evacuation plan for communities, the East Bank Roadway, schools, health centers, water wells, businesses, or FBOs surrounding the Schlumberger facility. Thank you.
Greetings of tranquil peace, Elizabeth Dean Hughes, co-applicant, member of Civic Society Guyana. I will approach the gas to energy project from the aspect of a lack of adherence to the rule of law and to ask the Honorable Commission to request information from the Government of Guyana. The GTE project in its current format has been so since 2020 without a feasibility study for the Wales location, nor any location with 25 kilometers of onshore pipeline. And there is no updated feasibility or pre-feasibility study since COVID-19 or the Ukraine war, which has skyrocketed the world prices. While we wait on the promised documents to be laid in the National Assembly, human rights are being destroyed under a lack of consultation for this project, a lack of the right to free, prior, and informed consent, failure to provide adequate information, lack of access to any information, and deals in non-disclosure inter alia. A few additional questions for the Commission to ask the Government of Guyana in light of the recent media reports from the international media reports, Reuters in particular, from the consultant head of the task force who has admitted to a delay in the project's timeline, due in part to foundation issues or geotechnical challenges. Yet, it is claimed by him that this project will be brought in on time and on budget. We're not sure which time or which budget, but the questions are, what are the additional costs to the project for these foundational and geotechnical challenges? What are the additional costs to the project for the delay to Guyana? And this project is only serving 68% of the population in the Demerara-Berbice interconnected system. What are the costs or financial implications for the pipeline's completion in 2024 and the NGL power plant startup in 2025? On the face value of the contrary to law and improper as adjudged in the Razik et al. Versus EPA et al. Case, environmental permit, and despite many letters written, there is no information on the rules governing the ExxonMobil's community grievance mechanism. There is no information on the stakeholder engagement plan nor the baseline study. All of these are listed in the environmental permit, the illegal environmental permit. And further, what is the proposed process and procedure to land the yet to be crafted gas leak management plan into the environmental permits? And the last question in this lot is, when will the land usage for Hermitage rails be changed from agricultural to whatever it needs to be for this gas energy project? Albeit the Attorney General and other high government officials have asked the courts and continue to refer to those of us who are seeking adherence to the rule of law as busybodies, nuisances, loonies, crazies, and other choice words, the Environment Appeals Tribunal, as mentioned by my other co-applicant, is yet to be established despite repeated requests. This refusal limits who can appeal EPA's decisions. In conclusion, I would like to highlight some aspects of the TikTok video which was shared at our application. I would like the timeline to be followed here. So the gazetted order was issued in January, printed for the properties in the right-of-way. In February, one of the owners in the right-of-way filed a case which challenges the whole process. Despite two previous attempts in October, ExxonMobil, along with the government of Guyana officials from the Ministry of Natural Resources, Ministry of Works, and surveyors, entered illegally onto the land, and that's the TikTok. Yet in October, the government of Guyana, through the Attorney General, applied for valuation of the same land, and the Registrar of Deeds, who was previously charged with fraud, made an annotation on that transport before the final determination that challenges the whole process and procedure of the right-of-way claim of the properties. Further, there are 2 sheets files for one property, only one of which corresponds to the order which was issued in January. This is the legal arena in which the GTE project is being applied across the board. There are other cases, and one very notable one is the one that challenges the constitution of the EAB, the Environmental Assessment Board, and its decision to waive the EIA. I would like to thank the Commission for this opportunity, my co-applicants, and the government of Guyana for any answers it can give to us before it files into the National Assembly. Thank you.
Greetings, Commissioners, IACHR technical team, and participants. Thank you for scheduling this hearing, which gives us the opportunity to air some of our deep concerns about developments in Guyana. I begin with a brief statement about Red Thread. Red Thread was established in 1986 as a multiracial independent women's organization not affiliated to political party, and which begins with grassroots women's lives across divides of race, age, sexuality, ability, and other differences. Our work is always carefully structured with this principle in mind, focusing on how issues like cost of living, defending the rights of domestic workers and security guards, usually women, domestic, sexual, state, and other forms of violence, and reproductive rights and health provide opportunities for grassroots women to come together across different communities to break silences and learn from each other in ways that benefit them and their communities and help build relations of trust. With the advent of oil production, the Guyanese public was told that significant inflows of money would be available for development, that Guyana would become the region's Dubai and more. Expectations in the communities were that the national standard of living would improve as the oil wealth was used to improve lives and livelihoods. However, when we compared our household budgets, we could not find the improvements that were promised. In fact, for the grassroots women with whom we organize, the cost of living was going up, house rents were through the roof, and the price of food was prohibitive. So we began to compare prices across communities for essential household items and for food which resulted in a couple of newspaper columns. The Stabroek News, a national newspaper, later began a weekly feature of people across the country, commenting on the high prices for essentials and how they were surviving. We called on experts and technicians to explain to us the information about the oil production arrangements that were in the public domain, since the published exchanges were way over our heads. We learned about the potential environmental consequences of deep ocean drilling that was happening, and we learned about the legal responsibilities of the Environmental Protection Agency in relation to the oil industry. We've been calling on the government of Guyana, and we continue to call for rule of law compliance in oil and gas to be ensured by our government. One aspect of the industry and the EPA law-breaking was the subject of an application filed by Frederick Collins and Godfrey Wright for orders of mandamus, prohibition, and declaration. The concern which we share is that the environmental permit with the oil company required a parent company full liability guarantee in the event of any production disaster, which clause has not been enforced by the EPA. As things stand, the oil company is liable only to the extent of their insurance coverage. To quote a small section of the judge's ruling, the antecedent circumstances giving rise to these proceedings for judicial review has disclosed the existence of an egregious state of affairs that has engulfed the Environmental Protection Agency in a quagmire of its own making. It has abdicated the exclusive statutory responsibilities entrusted to it by Parliament under the Environmental Protection Act 1996 and the Environmental Protection Regulations 2000. The EPA has relegated itself to a state of laxity of enforcement and condonation, compounded by a lack of vigilance, thereby putting this nation and its people in grave potential danger of calamitous disaster. Remarkably, this judgment, which sought to protect this country and people, was appealed by the EPA and the government. The orders were stayed by a higher court, and Exxon subsidiary, EEPGL, was ordered to lodge $2 billion insurance with the EPA. Whether or not this has been done remains a secret. We are very concerned about the appearance and maybe the reality that the government of Guyana is more concerned with appeasing the oil company than protecting the rights of our people and our environment. Thank you.
You have 1 minute, 20 seconds. Go ahead.
So, to conclude, what's our overarching right? What's our overarching objective here today? It's simply our constitutional right to a healthy environment and the restrictions we face in access to justice in related matters of public interest. The right to our role as citizens and environmental defenders enshrined in the Constitution is being denied by state actors through demonizing and insulting us and NGOs such as the Guyana Human Rights Association, Transparency Institute of Guyana, Inc., and Red Thread, as well as publicly calling activists, environmental defenders, and other stakeholders busybodies, obstructionist, unpatriotic, anti-development, and other derogatory terms, thereby creating an atmosphere of fear and intimidation. Yet, focusing on just 3 constitutional articles gives powerful guarantees to the role and right of Guyanese citizens and their organizations to fully and legitimately participate in such matters. Article 13 of the Constitution states, "The principal objective of the political system of the state is to establish an inclusionary democracy by providing increasing opportunities for the participation of citizens and their organizations in the management and decision-making processes of the state, with particular emphasis on those areas that directly affect their well-being. The Constitution also mandates, quote, every citizen has a duty to participate in activities designed to improve the environment and protect the health of the nation. Article 149J, in its turn, recognizes the right of every person to an environment that is not harmful to his or her health or well-being. Access to information is guaranteed within the framework of the freedom of expression. The Constitution states, quote, no person shall be hindered in the enjoyment of participating in the management and decision-making processes of the state, and constitutional guarantees are provided for in case of violation of such rights thereof. Article 149C, which is listed under Title I, Protection of Fundamental Rights and Freedoms of the Individual, reinforces this right. It sets out that, quote, no person shall be hindered in the enjoyment of participating through cooperatives, trade unions, civic or socio-economic organizations of a national character.
I'm so sorry, Ms. Radzik. Can you please wrap up?
Processes of the state. Article 149D,
Ms. Radzik, I'm sorry to interrupt you, but you have to wrap up.
The state shall not deny to any person equality before the law or equal protection and benefit of the law. Finally, this is where we stand today before the IACHR, powered by the courage of our convictions, protected by the Constitution and rule of law, which we fight to uphold, and committed
Okay,
to sustainable, honest.
I think you have to come to an end, Ms. Radzik.
That encompasses a harm-free environment, health and safety measures, and the right to justice, fairness, and well-being of the Guyanese people.
Yeah, I'm sorry you didn't hear me, but you did go well over your time. I would like to.
Roberta,
I would like to invite the representative of the state to make their presentation now. Thank you very much. State, can you please go ahead, Representative State?
Thank you. Good afternoon. Esteemed members of the Inter-American Commission on Human Rights, distinguished ladies and gentlemen, it is with a profound sense of duty and commitment that the government of Guyana takes this opportunity to address key issues raised in the January 24, 2024 correspondence from the Commission regarding the impact of private companies on human rights. Although the government of Guyana has taken note of the fact that the correspondence in question did not specifically emphasize which rights under the American Convention on Human Rights have purportedly been abrogated, the government considered it important to attend this public hearing to enhance the awareness of all concerned on the propriety of its actions, legal, regulatory, technical, and otherwise, with regards to the growing oil and gas sector. This we will do by addressing 5 key points arising from the correspondence. These are the legal framework for the environmental regulation of the petroleum industry, the environmental assessment process, access to justice in environmental matters, the technical prowess of the environment regulator, and access to environmental information. Foremost, it must be emphasized that Guyana boasts an extensive and forward-thinking legal framework for environmental regulations. While there can be no denying the fact that there is room for amendments, even in its current state, Guyana's local environmental laws continue to present a model for other countries around the globe, which have yet to make express provision for a constitutional right to a healthy environment. Whereas in many other petroleum producing states, the citizens' right to a healthy environment is non-justiciable or can also be domestically recognized, where a court is persuaded that it is implicit in other express justifiable human rights, such as the right to life. In Guyana, the right to an environment that is not harmful or human health or well-being is expressly provided for by the Guyana Constitution and enjoys full judicial protection. Article 149J of the Constitution of Guyana declares that everyone has the right to an environment that is not harmful to his or her health and well-being. Also continues to provide that the state shall protect the environment for the benefit of present and future generations through reasonable legislative and other measures, secure sustainable development and the use of natural resources while promoting economic and social development. This commission is asked to take note of the fact that the people of Guyana, through their constitution, have agreed to pursue the goal of sustainable development. This, as defined in the 1987 Brundtland Report, Our Common Future, and reinforced in Guyana's local laws, means development which meets the need of the present without compromising the ability of future generations to meet their own needs. It also poses a fair balance between environmental sustainability, social development, and economic development, and the pursuit of any one of the three pillars at the expense of another. In this vein, the Environmental Protection Act, Chapter 2005, requires the principal environmental regulator, the Environmental Protection Agency, EPA, to take such steps as are necessary for the sustainable use of the nation's natural resources. Sustainability is our watchword as a people. And as such, as the government, we cannot continue the elevation of environmental sustainability above social and economic development. We must balance all three. One of the key management tools utilized by the state to ensure the sustainable development of petroleum resources is the environmental assessment. Contrary to what the correspondence before this commission has indicated, the legal framework in Guyana allows for many forms of environmental assessments, of which one is the Environmental Impact Assessment, EIA. Indeed, there are many who hold the incorrect view that each and every project that touches and concerns petroleum development must be assessed by way of an EIA, simply because of the resource that is involved. However, this is not so. It is only where it is determined that a project may significantly affect the environment that an EIA is required. Precisely, this determination was made with respect to Liza 1 and Liza 2 projects, the Payara project, the Yellowtail project, and the Waru project, and so forth. It is not made in every case, nor does it need to be in order to guarantee environmental sustainability. The courts in Guyana have long reasoned that EIAs are not mandatory in respect of oil and gas projects, but rather the decision as to when an EIA is required is to be made on a case-by-case basis by the Environmental Protection Agency in accordance with the Environmental Protection Act. This same position was reinforced in a judgment earlier this week by the Supreme Court of Guyana in favor of the EPA. That is the Danuta Razik and others versus EPA and others. It must be emphasized that the government of Guyana recognizes a key aspect of the environmental assessment process is public participation, a form of which is consultation. This involves giving the body consulted a fair and proper opportunity to understand fully the matters about which it is being consulted and to express its views on those subjects. With the consulted thereafter considering those views properly and genuinely, precisely this is done during the EIA process. Contrary to the contentions made in correspondence before this commission, as it relates to the gas to energy project, members of the public were engaged through notifications, opportunity to make submissions, opportunities to attend scoping meetings, consultations, disclosure meetings, and many other engagements. Even so, as it is widely recognized across the world, adequate consultation is not evidenced by a final decision that is on all fours with everything every citizen indicated, each citizen indicated or expressed during the process. This can never be possible. As such, the EPA remains guided by the judicial guidance, which indicates that 1 is sufficient if those affected or likely to be affected are put into a position that allows their view and opinions to be heard, to be ventilated fully, and that those views and opinions are considered properly in the decision-making process. At the end of the environmental assessment process, whether by way of an EIA, or cumulative effects only, an environmental monitoring program, EMP, or otherwise, once a project is approved, an environmental permit disclosing conditions which are reasonably necessary for the protection of human health and environment is issued. In the case of the gas to energy project, among other things, this meant conditions related to gas leak management and gas integrity management. The absence of the language preferred in the correspondence before this commission, a gas leak management plan, gas integrity management plan, does not in any way indicate that environmental permit conditions pertaining to gas leak management and gas integrity management. Contrary to the intimidation level against the state of Guyana with respect to citizens' access to justice in environmental matters, the citizens of Guyana continue to enjoy their right, unhindered. In addition to the Environmental Assessment Board, EAB, which is an independent quasi-judicial body established by the Environmental Protection Act, the Supreme Court of Guyana, and ultimately the Caribbean Court of Justice, perform a supervisory role over the EPA. Citizens are in no way disenfranchised by the absence of an environment appeal tribunal, because any matter with the EAT would have been competent to hear, could be and have been heard by the Supreme Court of Guyana and ultimately the Caribbean Court of Justice. Further, in keeping with Article 8.3 of the Regional Agreement on Access to Information, Public Participation, and Justice in Environmental Matters in Latin America and the Caribbean, the citizens of Guyana enjoy broad, active legal standings in defense of the environment. This has been long recognized by the courts in Guyana and was recently reinforced in a judgment given by the Supreme Court in favor of the EPA, Razik versus EPA. Any contention alleging a clog in the citizen's right to freely access a fair and independent justice system is truly not true. No such finding has ever been made by the court of competent jurisdiction, and there is nothing to show any bias in favor of multinational cooperation in the environmental decision-making process in Guyana. There has never been any differentiation of treatment of persons on the basis of economic standing, nationality, or otherwise. This is never a consideration, nor can it be. The right to protection of the law guarantees every citizen adequate safeguards against irrationality, unreasonableness, fundamental unfairness, or arbitrary exercise of power, and ensures them the right to access the court and other judicial bodies to demand effective relief to remedy any breaches of their constitutional rights. The statutory mandate of the Environmental Protection Agency is clear. Taking such steps are necessary for the effective management of the environment. It is precisely what the EPA has been doing without fail ever since the discovery of petroleum resources and its subsequent development, commencing production in December 2019. The EPA continues to consistently invest in the development of its current workforce through specialized training initiatives in collaboration with the government of Guyana. Contrary to what the correspondence before this commission contends, external fundings or grants are only intended to enhance monitoring and enforcement capabilities. This cannot be taken as endeavors to its recruit a specific number of persons specialized in a particular field. There is nothing to indicate a lack of technical competence or capacity within the agency. Rather, the EPA continues to demonstrate its ability to maintain competent and sufficient staff to support the fulfillment of its statutory obligations. The Environmental Protection Act provides for a register of information to which every member of the public has access. Understandably, and as with all human rights, there exist reasonable limitations as to the amount of details that may be provided, the timeline within which the public can expect the information to be available, the time during which the public may access the register. Contrary to claims made regarding the inexistence of data regarding petroleum operations, the unavailability of environmental permits, and so forth, data and environmental information remain available via the EPA's Register of Information. Access simply necessitates compliance with the legally established procedures for same. For instance, any member of the public could have consulted the EPA's register and confirmed that the liquid mud plant with 32 large tanks, which the correspondents suppose may be operating without an environmental permit, is in fact fully permitted by the Environmental Protection Agency. In conclusion, whilst for some, the only satisfactory decision regarding Guyana's oil and gas industry would be a complete cessation of all petroleum activities such extreme determination. Such extreme determination would be contrary to the legal regime as set out both nationally and internationally. In addition to the clear expression of the goal of sustainable development as set out in the Guyana Constitution, the government of Guyana recognizes the principle of sovereignty over natural resources, which embodies the right of states and peoples to dispose freely of their natural resources. We also consider the Stockholm Declaration, which recognizes that developing countries need to direct their efforts to development, bearing in mind their priorities and the need to safeguard and improve the environment. Further, we are conscious of the United Nations Framework Convention on Climate Change, which acknowledges the fact that developing countries especially need access to resources required to achieve sustainable social and economic development. And that economic development is essential for adopting measures to address climate change. In view of these texts, it remains apparent that our country development and environmental protection are not irreconcilable aims. We therefore intend to continue our judicious pursuit of both with the full and effective participation of our citizens. And I want to add in conclusion too, that since taking office in August of 2020, our government has set as a priority the preservation and protection of the environment, while at the same time responsibly and sustainably, in a sustainable manner, explore and produce our natural resources to the benefit of all our people. And that is the mandate that was given to us as a government, and we intend to fulfill it to its fullest. We have so far ensured that the environmental permits are amended to ensure that there is a no flaring policy, and if there is flaring beyond the limit prescribed, that there shall be a tax or fee attached to it to ensure that there is no flaring. While many countries around the world are now making commitment to end flaring, Guyana has advanced in this area way before. We have also amended our environmental permit to ensure that there is cradle to grave management of waste, and that is critical. Treatment of water is critical, and to also ensure that environmental permits are made public so that anyone desirous of viewing these conditions and examining the conditions can do so easily. As a government, we will continue to work in the interest of our people, while at the same time protecting the environment at all costs. Guyana is a country that boasts high environmental credential, and this is something that we have prioritized as a government, and this is something that we are very happy with, and it is a commitment from our government that regardless of the development of our oil and gas sector and other natural resources, that the preservation of the environment, the well-being of our people, the protection of our people will remain paramount and key. So I just wanted to mention that in closing, and to say that we are happy for the opportunity to respond to comments in the correspondence and to bring some kind of clarity to some of the information that was mentioned in that correspondence of January 24th, 2024. Thank you.
Thank you very much, Minister. And now we have turned to the Commission for its reflections or questions, and then we return to civil society. Go ahead, Commissioner Caballero.
Thank you, Madam President. I'm going to speak in Spanish, but I would like to say hello to the state authorities and especially the human rights defenders present here by the Zoom platform. Yo estaba muy interesado en escuchar lo que dijeron, y tengo la inquietud sobre los temas de defensa en tres temas, y pues es una pregunta abierta a las defensoras, los defensores y al Estado. La primera tiene que ver con esto que ya las autoridades nos dijeron, es decir, que hay medios de transparencia abiertos, que hay incluso un interés legítimo muy amplio, que es de saludar, para que las personas puedan interponer acciones ante medidas que pueden violar el derecho al medio ambiente. Y en ese sentido preguntaría si en esas acciones amplias de legitimación, es decir, no necesitaríamos de un acto directo, sino en el interés de alguien que sienta afectado su medio ambiente, puede haber desde el Estado medidas cautelares, eficientes, amplias, que puedan suspender la violación del derecho al medio ambiente en lo que se tramita un juicio. Eso me parece que podría ser una pregunta de interés. El segundo tiene que ver con la defensa a los defensores y a las defensoras. Si el Estado tiene mecanismos de protección para quien ejerce la defensa del derecho al medio ambiente y de otros derechos, qué mecanismos hay, unidades de protección a personas defensoras. Eso resulta importante que se pueda comunicar también. Y en tercer lugar, digamos, si a largo plazo el Estado puede ir estableciendo estrategias que reconozcan el derecho de las comunidades a la protección del medio ambiente en un ámbito más estructural, y en esto en el entendido de que las empresas pues que llegan algunos con afanes extractivistas fuertes y que hay mucho dinero de por medio, pero por ejemplo con poblaciones que tienen un arraigo especial a la tierra y que tuvieran una atención del Estado en una dimensión de un alcance mayormente estructural de un Estado digamos, de derecho y de derechos humanos. Esos 3 puntos. Thank you very much.
Thank you very much. Commissioner Caballero, Commissioner Ralón.
Muchas gracias, Presidenta. Mi nombre es Eduardo Ralón, comisionado. Quisiera saludar a los representantes de la sociedad civil, también del Estado. Creo que es muy importante que este tema se esté conversando en el marco del periodo de sesiones. La información que ustedes nos brindan pues nos permite a nosotros estar mejor enterados y poder abordar de una manera más adecuada cualquier situación que tenga que ver con el derecho al ambiente, con el tema de empresas y derechos humanos y específicamente de la actividad petrolera y del gas de Guyana. Yo tengo unas preguntas. La primera dirigida para el Estado. ¿Qué medidas ha adoptado el Estado para garantizar el derecho a la información y a la participación de la ciudadanía o grupos de interés con relación a la industria de petróleo y de gas? Es decir, ¿cómo pueden ellos acceder a esa información? ¿Cómo se les puede tomar en cuenta para conocer cuál es su punto de vista sobre un proyecto que se vaya a autorizar o sobre las afectaciones de un proyecto que ya esté funcionando? ¿Qué canales hay de comunicación y de acceso a la información? Y la otra pregunta, más dirigida a las organizaciones de la sociedad civil. Nos han presentado ustedes una serie de denuncias, de situaciones que les afectan. Legalmente en Guyana, ¿en dónde se presenta un reclamo o qué mecanismos de defensa tienen ustedes para iniciar un proceso para que se revise o se corrija alguna afectación que se le esté dando por esta actividad de petróleo o de gas? ¿Cómo es que funciona y dónde pueden ustedes reclamar para que algo se corrija? Esa sería mi pregunta. Muchas gracias, Presidente.
Thank you very much, Commissioner Ralón. I want to once again give some words of appreciation to civil society organizations that are participating here, as well as to the State Minister and other representatives. As I understand it from the presentation of civil society, and I have to say it was full of detail, and I hope that you all can send us the written version so that we can properly see it. Some of it went a bit fast for us to digest. But from what I was able to gather, it seems to me that there are 3 concerns that are being raised here. One, the question on due diligence for environmental management and environmental protection, whether or not all of the actions that should be taken to prevent environmental harm or damage to the right to healthy environment, are those actions being taken? That's the first question. The second question, I set of questions I understand around accountability, whether or not there's a state accountability or sufficient state accountability for actions which may be seen as violating the rights of citizens. So, for example, I understand from Ms. Elizabeth Dean Hughes, although there was some question of land, illegal entry onto land, and the question about whether or not there was a recourse or has been a recourse to address that illegal entry onto land. It's not clear to me, Ms. Dean Hughes, whether or not who entered onto the land. So maybe you can clarify that when you speak. So the question of accountability on rights violations, whether perpetrated by state or non-state actors. And then the question of the accountability by way of appeals processes. So we've heard there are two appeals processes in relation to environmental management. One, the Environmental Assessment Board, I hope I have that right, and the second one, the Environmental Appeal Tribunal. On the Environmental Assessment Board, the civil society representatives here are suggesting that that board may be not comprised of the level of expertise that is needed, or may be comprised of persons who may not be fully independent because of perhaps they may be representing the state through their job functions. And then that the Environmental Appeal Tribunal has not been constituted. With regard to that, I want to ask the representatives of civil society. The minister has said, in fact, yes, the Environmental Assessment Board may not be constituted, but there are other recourse. There's other recourse for justice. There's access to court. So I would like to have your reflection on what do you think is the comparative advantage of a constituted environmental tribunal over a court? Is there a difference here that we should be paying attention to? And then the third area that it seems to me that is being raised by civil society, so to recount due diligence on management, accountability, and then the third big area seems to be participation. That civil society may not be fully included, or as components of civil society may not be fully included, and that the publics, in plural, may not have all of the access to all of the information that is needed to ensure that they can comment on state policy. And also that environmental defenders may be stigmatized. I think we heard you all speak about the language, the environmental defenders being called busybodies, for example. So certain stigmatization of environmental rights defenders. So for my question for civil society, I think I've asked you already, what is the comparative advantage in your mind in a specialized tribunal as opposed to access to courts? And for the state minister, I wanted to ask about the appeals processes. In relation to the Environmental Assessment Board, having regard to what civil society representatives have said, can you advise us on how the board is constituted so that its competence is assured as well as its independence? And then secondly, in relation to the Environmental Assessment Appeals Tribunal, what would be the mandate of such a tribunal? And are there plans to constitute that tribunal in the near future? Thank you. So we now give it over to representative civil society. Ms. Radzik, I had to interrupt you in the first round, so you may answer the questions or you may start. I don't know how you all want to arrange it, but you have, I think it's 7 minutes? 12 minutes, so you have 12 minutes. Thank you.
Thank you, Roberta. So in terms of the Environmental Assessment Board, with respect to the current 3 members and past, the problem we have is that all 3 members on what is supposed to be an independent assessment board are all high-ranking government officials, And it begs the question, therefore, of their independence, because they're all employed by government agencies. Also, in the Act, Environmental Act, there is provision for a 5-member board. And we have argued in the press and in the court that 5 members should be appointed to the EAB, the Assessment Board, and the 2 of those members must be professional, competent civil society experts in environment, etc., in order to counterbalance and to establish a greater independence of this all-important EAB. In terms of the tribunal, Roberta, it doesn't exist. And yet, in the Act, provision is made for this independent 3-member tribunal. And we feel that, that in fact, if that existed, we would not have, what we have is only the recourse left to the, to go
I'm sorry, we're not hearing.
whereas the tribunal could be an interregnum should the EAB, scrap. You're not hearing me?
Yes, go ahead now.
Right. Yes, that the tribunal is the interim body that should be there for us to access prior to moving to the court. We move to the court now all of the time, but there ought to be this interim. Finally, Section 11 of the Environmental Protection Act is specific in calling for an EIA on significant projects significantly affecting the environment. How can the minister say that projects such as massive offshore floating platforms drilling millions and millions of barrels of oil a day is not a significant project? How can they say that an establishment of a radioactive calibration facility with toxic chemicals, etc., situated in the middle of a long-standing residential area is not a significant project? These are things in the oil and gas industry that Guyana has never experienced before in our whole history. All of them deserve the merit of a professional and independent EIA. Thank you.
Right, and I would just like to speak a bit about the whole process. The minister, frankly, I don't think the minister answered any of our questions, and that is unfortunate. But when we come to the process in relation to environmental impact assessments, because that is what is there in the Environmental Protection Act. The other mechanisms he spoke about, those are not the main things that have to be done if there is a clear possibility that a project could affect the environment, right? And the process is that any project who wants to get an environmental permit has to do certain things. One is that they have to provide a summary of the project, right? The design and size of the project, the possible effects on the environment, right? A description of the project and a non-technical explanation of the project. This is written into the EPA Act of Guyana. Now, some of the companies I referred to in my presentation, they have no summary on the EPA's website. There is no summary. So how did they get an environmental permit when the process was not followed? And so there is nothing on the EPA's website. There is no project summary which speaks about Schlumberger's or Halliburton's, and these are two separate projects. They're not together. There is nothing that speaks about a mud plant, nothing. There are other projects that are on the website, but that is not. Tiger Rentals has no project summary on the EPA's website. That is the process. It is not there. And yet Tiger Rentals was the company from the beginning, right? who was responsible for dealing with hazardous waste. The environmental, the EPA's, their own form for hazardous waste is not there on the EPA's website. It does not exist. I had to find it in ExxonMobil's comprehensive waste treatment plan. Now, why, if what we Guyanese need, we are living in communities, and these oil and gas companies come and establish these projects within our communities, dealing with hazardous waste and other hazardous materials, right? And yet, that form which the public and people who live in communities should be able to access. There should be a report on this. It is not there. In fact, there is no annual EPA report since oil and gas came to Guyana. Prior to oil and gas, every year, the EPA had on its website, there was a report, annual report, right? So I just wanted to clarify that. There were a lot of questions asked. Mechanisms for protection for defenders of the environment. We have none. We would have to go to court about these matters, and that is it is difficult, it is expensive. We have to employ, or we would have to pay lawyers to do this. There's no mechanism available for defenders, which is not costly and time consuming when we have been attacked, as mentioned in this, in the presentations. And Liz, maybe you'd like to speak to your experience.
Thank you, Danuta. So I would like to corroborate Danuta with the Honorable Minister has answered none of the questions posed here, none of the questions posed in the 300 emails sent to the government of Guyana and ExxonMobil. So, Roberta, to quickly answer your question, the people who entered illegally onto the land were the government of Guyana, Ministry of Natural Resources and Environment personnel, Ministry of Works personnel, ExxonMobil's ExxonMobil's onshore manager, and other ExxonMobil employees, along with the contractors, GEICO and CSIM. Those were the people who entered illegally onto the land, and this is being done in a process where the registrar of deeds, who has been charged for fraud, has signed on annotated transport before the determination of a case which challenges the legality of the process. And quickly to refer to the minister's insistence that we have consultation, I'd like it to be noted that the residents in Canal Number 1, the letter has been submitted to the Commission. It was submitted to the EPA and ExxonMobil, objected to the fact that they were not consulted before in the consultation process. This was also admitted by ExxonMobil at their community outreach services after the submission of the EIA. So I would like to have that on record as a refute. And the minister talks about the gas leak management plan. Up to last week, I called the CDC, which is responsible for the oil management plan, and they were informed that they don't even know what is going on. In the press, we saw that different Middle Eastern countries were to help us with this plan. This plan is a necessity under Section 11. I will stop there so Karen can speak. The rest will be in writing. Thank you for the opportunity.
Karen, this is the red thread. Thanks, Liz. I just have one comment to make. Yes, there is in principle access to the courts for some of the law breaking that is taking place, but I'm speaking from a constituency in which people have to make choices, such as whether they will be able to eat today or go to the doctor today. So in a situation like that, there is absolutely no likelihood of being able to file a case in court, as has been mentioned. Court court cases cost a lot of money. And just to reiterate, the constitution of the board of high-ranking government officials, our objection is not necessarily that they work for the government, but the objection is in the context of Guyana, there is a difficulty of independence and taking independent decisions that are in line with the work that you're supposed to be doing. As the notice said, mechanisms to protect human rights defenders. All we get is more abuse. I mean, Red Thread has been threatened in various ways, and we have got no recourse, not even from the police that we have made reports to. So that's I won't attempt to answer any other questions there. Thank you.
And if I could just also speak a bit about
You only have 15 seconds, though.
right, access to information. That does not exist, right? As I said, the EPA's hazardous form, right, is not available. It is their form. It is not available on their website. How are citizens supposed to know that such a thing exists where we can see clearly what are the types of hazardous materials and how they are being used, right? And in terms of processes, EIA processes and consultations, et cetera, you know, the EPA, what they do is they advertise a project and say there is this project happening.
Okay.
It is advertised in one newspaper on a Sunday.
I'm so sorry, Ms. Radzik. I have to cut you off. Unfortunately, we've run out of time. And we do have to be sort of rigorous and fair about the time. Minister, over to the state and its representatives for your response to the question from the Commissioner or anything else you wish to speak to.
Thank you for the opportunity to make some brief comments and to respond to a few issues that were raised before I hand you over to Mr. Bashram, who is the head of the Environmental Protection Agency, to deal with specifically in greater detail, some of the issues that were raised. I just want to state from the onset that it is the right of any citizen of Guyana to seek redress in the court of law, as has been happening and as was done by many of the civil society reps being represented here today. And I want to believe too that some of the contentions that are being made here, there were recent rulings, court rulings, on the very contentions that are being made here today again. So I just wanted to make that point up front to show that there is recourse through the court, especially with recent court ruling justifying the government's position and EPA's action. I am a bit baffled with regards to the comments, the accusation of comments being made towards civil society activists. I can assure you that government has made no comments with regard or derogatory comments with regards to civil society activists. But what we do wish as a government is for civil society activists to be fair, balanced, and apolitical too in whatever they do in the representation of issues and the people at the same time. The other thing I want to mention too is that the EAB, it was mentioned that it constituted by senior government officials. I want to say that these are senior professional public servants and not elected members of government, because it may come across as though these are elected members. They are not. They are professional public servants. Also, I wish to state that citizens of Guyana, they're given adequate opportunity in a consultative process. They're given adequate information via the EPA website, via the Ministry of Natural Resources, the Ministry of Finance, and many other portals that is available. I know for sure that before a production license is issued, there are several consultations being held countrywide, of which many of the civil society activists present here today usually are in audience and would make comments at those very consultation too. I want to say too that this oil production that we speak of, it is actually 100 miles offshore Guyana, and it is not onshore. So I assure you there is no exploration activities onshore or within our land boundaries, but rather it is in the maritime space of our country. Now, there are many calls to stop oil production in Guyana, but we need to look at it realistically. We need to look at it in a way that a government has a responsibility to provide for its citizens. A government, especially in the context of climate change now and moving towards renewable, has a responsibility to ensure that we transition away from fossil fuel to renewable energy. We have a responsibility to our people to ensure that there is enough mitigation adaptation measures against climate change. We have a responsibility at the same time to ensure that there is economic and social development of our people and country. Now, the only way we can achieve this, the only way we can successfully achieve this is to ensure that we explore and produce our natural resources in a responsible, sustainable manner, and at the same time protecting our environment. And I think Guyana is a model oil producing country around the world now, especially with our high environmental credential. Finally, before I hand you over to the head of the EPA and the gas energy project, this is a project that will transform our country. This is a project that will reduce the cost of living. I think one person mentioned that, will reduce the cost of living of our people and improve the standard of living of our people by delivering reliable, cheap electricity, and in the context of climate change, cleaner electricity, cutting our emission for power generation by a 40 to 70%. So it is a project of national importance that will benefit all Guyanese either directly or indirectly. So I wanted to make those few comments before I hand you over now to the head of the EPA. Thank you.
Thank you very much, Minister, and thank you and good afternoon to colleagues and commissioners. Several issues, specific issues, were raised by our colleagues on the other side there in terms of the civil society members. And some of the questions raised by members of the commission, I will basically give an overview of the process of our decision making, and it will probably give you clarity on some of the questions that you've raised. So the Environmental Protection Act provides for, there's a schedule of projects that are listed in the Act that basically says those in those schedule, any project which may have significant impact, apply for an environmental authorization. And the agency, from the application and from its process of screening and site inspections, utilizing technology, utilizing the information that's provided by the developer or the proposer, makes a determination if the potential impacts may lean towards being significant or not. If it leans towards being significant, then the requirement, then and only then the requirement for an EIA is stated. No EIA, no requirement for an EIA is mandatory. It is at the discretion, it is at the discretion of the competent authority, which is the Environmental Protection Agency. Now, when an EIA is determined, and in all of the development projects offshore, from ESA 1 to the current one currently under consideration, an EIA was required. And as part of that process, the environmental impact assessment process is standard and is equivalent to any process globally. There is a notification in the newspapers, which the EPA publishes, saying that an EIA is required, and the public has 28 days to make written submissions for any questions, any queries they may have towards contributing to the development of a terms and scope for that EIA. Now, that is the only requirement in the Act, but the EPA over the years, at its discretion, held public face-to-face consultations across the entire region. And we're talking about the oil and gas sector here. And if you know the geography of Guyana, from regions 1 to 6, there were consultations, what we call scoping meetings. And it's open to any member of the public. The outputs of those sessions are the terms and scope based on the concerns raised at those meetings, which is developed with the EPA and the consultant approved by the EPA that is suitably qualified and experienced to conduct an EIA. When the EIA is conducted and submitted to the EPA, there is another statutory period of 60 days published in the newspapers again for the public to review those EIAs. The EPA instructs the developer to place those EIAs at key areas, key locations, to ensure that the public has access. And in fact, again, the EPA ensures that consultations, or what we call public disclosure meetings, are held across the regions again, explaining the results of the EIA and the findings. Now, all of that information coming into those EIAs are then submitted to the Environmental Assessment Board. The Environmental Assessment Board, independent of the EPA, reviews that. And if they require, they may seek or solicit additional expertise to support their decision-making and review of that EIA. The EAB then makes a recommendation to the EPA to say whether the EIA is acceptable or not, and what terms and conditions a permit or an approval should be granted if the EIA is found acceptable. The EPA then takes that recommendation from the EAB and decides to approve the project by issuing a permit. That permit then would also have specific measures, including recommendations received from the EAB, including recommendations that we would have heard and thought useful from the public in all of these consultations to ensure that adequate safeguards are in place if the project is approved by virtue of this permit. So throughout the whole measures, there are opportunities for public consultation, for participation, public participation. And that is a key aspect and tenet of the EPA's approach to ensuring when we are authorizing projects. After authorization, there is compliance, is another aspect. We are ensuring we have the capacity, we're talking about capacity of the EPA. It's not just about one sector of the EPA or one department of the EPA. It's building the capacity of the entire agency, from legal to engineers, to technical to environmentalists, to public education and awareness specialists, to ensure that our full mandate is executed and ensuring compliance with the permits thereafter. So that is in a nutshell is the process and the procedures that we undertake to ensure that what we do is in keeping with the Environmental Protection Act. Thank you.
Thank you very much, Minister and representatives of the state. And so we are at the end of the hearing, number 18, on the impacts of private companies on human rights in Guyana. If you may allow me to just give a quick summary remark, it seems to me that there's quite a bit of agreement on the requirements, on some of the requirements for due diligence in the management of natural resources and to ensure a healthy environment. There's I think, certainly a consensus on that. There's a consensus certainly also on the need for accountability and also for accountability mechanisms, whether it's the court, the EPA, the Environmental Assessment Board or tribunal, but certainly that accountability is an important part of the framework of maintaining a good regulatory space for the monitoring of the use of natural resources and to maintain a healthy environment, and also the importance of participation of civil society based on a free flow of information. So I think that there's consensus on those principles. There is, of course, less agreement, and there seems to be substantial difference on whether or not those principles are being met or being implemented as effectively or at all, depending on whether you're a representative of the state or represent civil society. I only say that to say it's not for the Commission to make a determination on that, but to say there may be a way forward, and there always should be a way forward, having regard to the importance of civil society in ensuring state accountability. Sometimes is uncomfortable, but that's the role of civil society in the maintenance of a democracy. And so we just urge, from the side of the Commission, we urge continued engagement between the state and the representatives of civil society, and all representatives of civil society, not just those who are here. And we look forward to continuing to monitor the situation in Guyana and being available to the state and to civil society representatives for technical cooperation and engagement. Unfortunately, our Special Rapporteur on the Economic, Social, Cultural, and Environmental Rights was unable to be here with us today because he's attending another hearing. But we will give him a brief. He will have access to the recording of this hearing, and certainly, Minister, he will make an outreach to the state and to representatives so that he can follow up on any questions that that require his attention. So with that, I want to thank you very much, everyone. Minister, you and your team, civil society organizations, and to the commissioners here. Thank you very much, and I now bring the hearing to a close.
Thank you.